A cold, sharp voice pierced the breathless silence of the courtroom. "Mr. Elon Musk, your actions demonstrate a blatant disregard for the law." The Supreme Court seemed poised to deliver a public reckoning, an example made of a defiant tech billionaire. But Musk didn't flinch. Instead of bowing his head in shame, he opened a red folder, and the entire hearing flipped on its head. What began as a disciplinary showdown quickly turned into a historic moment, where the truth exposed an entire system. It was supposed to be the day Elon Musk finally got humbled. The headlines were already written, just waiting for quotes. In room 2141 of the Rayburn building, where reputations go to either rise or unravel, politicians, legal aides, and media insiders had gathered like vultures circling a man they thought was already halfway buried. The subject? A high-profile Supreme Court-style hearing involving Musk's company, X Corp, and a series of alleged violations related to federal communication regulations. But no one came for technicalities. They came for a show, and they came to see Elon Musk get put in his place. Justice Amy Coney Barrett was seated high on the bench, robes crisp, her gaze sharper than a gavel. She had a reputation, an iron constitutionalist with no tolerance for billionaire grandstanding. Musk, they said, was about to be taught a lesson in humility and legal submission. This was her turf, and Elon, just another tech guy who thought money meant immunity. Musk walked in quietly, no entourage, no dramatics. Dark blue suit, no tie, just a red leather folder in his hand, and the kind of calm that makes enemies nervous. He didn't flash his signature smirk. He didn't need to. The room was packed, standing room only. CNN and Fox had both sent crews. C-SPAN was live. Legal scholars from Yale and Stanford were seated in the back, notebooks ready. A few staffers were already drafting tweets about how Musk finally got a reality check. Then it began. Justice Barrett wasted no time. "Mr. Musk," she said, her voice clear and commanding, "your company has received 17 formal compliance notices from the FCC and failed to adequately respond. Why should this court interpret that as anything but deliberate noncompliance?" Musk didn't flinch. He simply leaned forward and said, "It was 16, Justice Barrett. The 17th was a clerical duplication." The entire room blinked. A billionaire correcting a Supreme Court justice on live television? Bold. Stupid? Maybe. But there was no stutter in his voice. No smugness either, just precision. Barrett's jaw tightened slightly, her eyes narrowing. "So noted," she said, icy. From there, it was supposed to go downhill for Musk. The plan was to pile on the pressure, make him sweat, maybe even fold. The government's Solicitor General came out swinging, accusing X Corp of skirting not just rules, but democracy itself. He even dropped the word threat. That usually rattles a courtroom. But Musk sat still, occasionally flipping through the red folder like he was reading a brunch menu. That's when the shift began. "May I?" Musk asked, motioning toward the microphone again. He didn't wait for permission. He opened the folder, pulled out a document, and said, "This is an internal FCC email from March of this year. It refers to leveraging compliance audits to influence moderation standards without triggering First Amendment challenges." Their words, not mine. Barrett blinked. The Solicitor General froze mid-rebuttal. The press gallery collectively leaned forward. Musk wasn't just defending himself. He was flipping the script. He didn't just bring evidence. He brought receipts, references, annotations. And as it turned out, he had been studying Barrett's own legal opinions. Word for word. "I based my response to the FCC," he said, "on your majority opinion in Net Choice v. Paxton. You wrote, and I quote, 'Government agencies cannot use regulatory threat as a substitute for legislative authority.' That's exactly what happened here." Silence. Not awkward. Deadly. This wasn't the lecture Musk was supposed to receive. It was the one he came to deliver, and the courtroom, once so ready to watch a takedown, now sat stunned, recalculating everything they thought they knew about the man in the chair. And this was just the beginning. Elon didn't blink. While most CEOs would have cracked under the weight of a Supreme Court hearing, Musk looked like a man who had just found the bug in the system and couldn't wait to show his work. Justice Barrett sat forward, ready to strike again. Mr. Musk, she began, even if what you say has merit, your company still ignored 16 formal directives from a federal agency. That's not just bold, it's borderline reckless. Elon leaned in, calm as ever. Justice Barrett, with respect, I believe our actions were not reckless, but necessary. And if the court will indulge me, I'd like to demonstrate why. He clicked his remote. Behind him, the projector lit up, not with a fancy logo or PR graphic, but with a simple, bold title, FCC Compliance versus Constitutional Authority. You could hear the air shift. Some aides sat up straighter. Others leaned in with curiosity. Barrett didn't stop him. Neither did Roberts. Musk continued, what we're dealing with isn't just about content moderation, and it's not just about federal directives. It's about the boundaries of government power and whether regulatory agencies can bend the Constitution without technically breaking it. He clicked again. This time the screen displayed a timeline. On one side, the Net Choice v. Paxton ruling, authored notably by Barrett herself, outlining that the government cannot pressure private platforms to host or remove content. On the other side, a list of FCC emails now unsealed, showing how internal teams discussed using technical enforcement to nudge platforms into removing certain speech. Musk didn't point fingers. He didn't raise his voice. He just let the documents speak for themselves. Here, he said, gesturing to a highlighted quote, Commissioner Thompson writes, and I quote, Barrett's opinion limits us publicly, but if we reframe this as a technical audit, we can force adjustments indirectly. There was a noticeable shift in the room. Justice Thomas furrowed his brow. Justice Kagan glanced sideways at her clerk. Even Barrett, composed as ever, was reading the document more closely now. But Musk wasn't done. He turned back to the bench. We didn't defy the government blindly. We challenged their overreach strategically. We filed motions in the 5th, 9th, and D.C. circuits. We requested stays. And while 2 circuits split, Justice Jackson herself called the constitutional questions substantial and unresolved. That's not defiance. That's due process. Justice Alito spoke next. Mr. Musk, you're not a lawyer. Who advised you on these matters? Musk allowed a small smile. Well, Your Honor, I've spent the last 11 months reading every major Supreme Court ruling on speech, regulatory limits, and executive overreach. I read your dissent in Packwood, Barrett's opinion in Net Choice, even Justice Sotomayor's concurrence in Knight First Amendment Institute versus Trump. No offense to counsel, but I didn't want to delegate this one. A low murmur rose in the gallery. The press was scribbling fast. Even CNN's legal analyst had stopped shaking his head. Barrett narrowed her eyes, but it wasn't hostility anymore. It was interest. And what exactly is your legal position? That the FCC, Musk said plainly, used bureaucratic muscle to achieve what Congress never authorized and what the First Amendment explicitly prohibits. Then the folder. Again. The infamous red folder. Musk pulled another document, an internal memo marked Confidential. Highlighted was a section titled Strategic Alignment with Executive Messaging. Beneath it, a bullet point, ensure platform compliance with administration's stance on disinformation. He didn't say, I told you so. He didn't need to. Barrett read the memo, quietly, carefully. Then she looked up. Is this document authenticated? Yes, Justice. Obtained through FOIA, certified by chain of custody, time-stamped March 3rd. There it was, the silence of acknowledgement. What began as a legal ambush had just become a courtroom pivot of historic proportions. And Elon Musk, the supposed defendant, wasn't defending anymore. He was prosecuting, using the very language of the law to flip the hearing upside down. And the justices, they weren't just listening, they were learning. Elon Musk didn't need theatrics, he had the documents. With the courtroom hanging on every breath, Musk reached into the red folder once more and slid a packet to the court clerk. What you're about to read, he said calmly, is not a theory, it's not an interpretation, it's proof, straight from the FCC's internal servers. Justice Barrett, now fully alert and focused, took the documents as the projection behind Musk flickered to life. It displayed a series of email headers, all marked with timestamps and sender addresses from within the FCC. One by one, highlighted lines popped onto the screen. Let's start with Exhibit A, Musk began, his voice steady and precise. An internal communication dated August 17th, 2023. Subject line, workarounds to Barrett's ruling. There it was, black and white, no ambiguity. The email read, "We may not be able to compel direct moderation anymore, but leveraging technical certification and compliance metrics gives us backdoor influence. Consider classifying certain failure to comply flags as public safety violations." The room stirred. Reporters scribbled. A few gasped. Even Justice Alito narrowed his eyes. Justice Kagan leaned toward her microphone. "Mr. Musk, are you suggesting the FCC knowingly re-engineered regulations to bypass Supreme Court precedent?" "I'm not suggesting, Justice Kagan," Musk replied. "I'm quoting." He clicked again. Exhibit B appeared, this time a PDF memo from Commissioner Thompson himself. Highlighted in yellow, use pre-certification requirements as pressure points. Platforms must be made to understand that moderation alignment is the path of least resistance. Barrett leaned forward, her voice low but sharp. "Counselor," she turned to the Solicitor General, "was this material made available to any lower court during the prior proceedings?" The government's attorney shifted in place. "No, Your Honor. These documents were obtained only recently." "Through a FOIA lawsuit," Musk cut in, "filed 6 months ago and resolved 3 weeks before this hearing. We submitted discovery requests. The FCC fought everyone." Barrett's gaze was piercing now. "Then we are reviewing a case built on what may be, in part, deliberate omission." The Solicitor General opened his mouth, but Musk had already moved on. "Here's where it gets worse," he said. "This isn't just about my company. The FCC's internal strategy memo from November 2023 outlines a broader enforcement approach. Target non-compliant platforms first, establish pattern, create chilling effect industry-wide." He turned back to the justices. "That's not regulatory discipline. That's coercion by design." The room was frozen. Every justice now had their head down, reviewing copies of the memo. Musk's voice lowered. "They didn't enforce the law. They manufactured pressure. They weaponized the tools of compliance. Not for safety, not for neutrality, but to steer speech." He took a breath and then added with a touch of irony, "If this is how the government defines public interest, maybe it's time the public redefines the government." It wasn't a mic drop, but it was close. The shift in the courtroom was almost imperceptible at first. No banging of gavels, no gasps. Just the quiet, collective tightening of posture. What began as an anticipated grilling of a tech billionaire was suddenly transforming into something far more serious. The judges, who had moments earlier seemed skeptical, even borderline dismissive, were now flipping through the red folder with renewed focus, some underlining, others murmuring to clerks. Justice Barrett, who had started the session with sharp questions and a tone that suggested she was ready to put Musk in his place, now leaned forward, not to interrupt, but to absorb. Her fingers tapped against the edge of the bench, not impatiently, but rhythmically, as if working through a complex equation. Across the bench, Justice Kagan exchanged a glance with Justice Sotomayor, one of those glances lawyers dread. It said, "We need to look closer." Justice Alito adjusted his glasses and began annotating his own copy of Musk's submissions with a yellow mechanical pencil. Even Chief Justice Roberts, seated with his trademark composure, crossed one leg over the other and rested his chin on his hand. A clear sign that his mind was now fully in the ring. From the government side, the mood was shifting too, but not in the way they'd hoped. The FCC's legal counsel, who had started the hearing with a confident stride and media-ready soundbites, was now thumbing anxiously through a manila folder, whispering furiously to a junior staffer. Their once triumphant energy was draining, replaced by the slow realization that this wasn't going according to script. Then, as if to punctuate the shift, Justice Jackson spoke, calm, measured, but direct. "Mr. Musk, your FOIA documents suggest a regulatory pretext aimed at indirect speech control. That's a serious charge. Can you connect these communications to actual enforcement behavior?" Musk didn't blink. Absolutely, Justice Jackson. We mapped every enforcement action issued by the FCC since June 2023 and cross-referenced them with the dates of these internal memos. The overlap is not random. The pattern is prosecutorial retaliation disguised as routine oversight. Barrett looked up sharply. And you have that pattern documented? We've submitted a 37-page appendix with statistical breakdowns and timeline correlations, Musk replied, lifting another sheet from the folder without fanfare. We color-coded the enforcement clusters by region and topic. Content-based actions are overwhelmingly concentrated on platforms that resisted the directive language. At that moment, the room no longer belonged to the government attorneys. It belonged to the argument, to the data, to the questions that could no longer be brushed aside with bureaucratic jargon. Barrett leaned back, her tone almost dry. It seems this court may have been handed an incomplete picture of the FCC's conduct. Counselor, she turned to the Solicitor General, will require a full and unredacted review of the communications presented today. Expedite the process. We are now dealing with potential constitutional implications. The Solicitor General nodded tightly but said nothing. There were no more smirks, no smug tones, just the uncomfortable silence that fills a room when power realizes it's no longer unquestioned. And Elon Musk? He simply returned to his seat, calm, silent, the red folder still resting in front of him like a grenade no one dared touch. The room had barely settled when Elon Musk leaned forward again, the same calm in his eyes that now looked less like arrogance and more like calculation. What had started as a defensive posture was shifting, rapidly. This was no longer a man fighting off a lawsuit. This was a man flipping the courtroom upside down, one precedent at a time. Just to clarify, Musk said, his voice measured but loud enough to command the room, this isn't about my company avoiding regulation. This is about whether the FCC attempted to circumvent this court's own ruling using bureaucratic camouflage. He lifted another document from his now infamous red folder. The header was simple. Precedent summary, judicial overreach safeguards. Let's talk about Youngstown Sheet and Tube Company versus Sawyer, Musk began, scanning the room. This court made it clear that even during a national emergency, executive authority doesn't give federal agencies the right to fabricate power they were never granted by Congress. What we're looking at here, these memos, these enforcement strategies, they're not interpretation of law. They're invention of law. Justice Alito tilted his head, intrigued. Musk was no longer reacting. He was leading. And if I may, Elon continued, we also cited Bantam Books v. Sullivan, where this court ruled that informal pressure by government agencies to suppress speech without formal legal procedures is unconstitutional. In that case, it was a state commission threatening publishers. In this case, he held up a memo from the FCC's internal communications. It's a federal agency targeting speech platforms with veiled regulatory threats. Justice Barrett raised an eyebrow. Are you asserting that the FCC attempted to act as an unofficial censorship arm of the executive branch? Musk gave a slight nod. Exactly. They couldn't mandate content controls directly, so they tried to do it sideways. Call it regulatory laundering. It's censorship disguised as compliance. A few spectators gasped. The FCC's lead attorney paled. The Solicitor General, once confident, now sat stone-faced. Justice Thomas leaned toward his microphone. Mr. Musk, are you asserting that this court is being asked to validate a structure that undermines its own authority? I'm asserting, Musk replied, that if the FCC's tactics are allowed to stand, it sets a precedent where the Constitution becomes optional. So long as the pressure is informal, the language is vague, and the enforcement is buried in footnotes. A low murmur ran through the chamber. The red folder had gone from spectacle to scalpel. Each citation, each example, sliced away the narrative that had brought this case before the court in the first place. Musk didn't stop there. In fact, he added, holding up one last document, we submitted affidavits from 2 former FCC officials who anonymously confirmed these tactics were discussed explicitly. Their words? The agency knew it couldn't win in court, so it played a long game of regulatory attrition. He paused. So now the question isn't whether we broke the law, it's whether the FCC broke the Constitution trying to force us into silence. The judges didn't say a word. They didn't have to, because in that moment, everyone in the room knew Elon Musk wasn't on trial anymore. The system was. The silence that followed Musk's last statement was deafening. Not the kind born of awkwardness, but the kind that signals a shift in the room's gravity. Justice Amy Coney Barrett, who had opened the hearing with sharp skepticism and a tone just short of reprimand, now sat quietly reviewing the documents Musk had provided. Her brow furrowed, but not in frustration, in focus. She set her pen down. "Mr. Musk," she said, her voice no longer edged with suspicion, but now weighted with genuine inquiry. "You're saying these regulations, on their face, were designed not to protect public interest, but to bypass the constitutional safeguards outlined in NetChoice versus Paxton?" Musk didn't smirk. He didn't gloat. He simply nodded once. "That's correct, Justice Barrett. Your own majority opinion in that case laid out the exact boundaries they crossed. I didn't reinterpret it. I followed it." There was a moment of stillness before Barrett leaned back in her chair, almost imperceptibly. Her expression shifted, not softened, but recalibrated. "I must admit," she said slowly, "I did not expect this level of constitutional analysis from someone without a legal background." That drew a quiet chuckle from the audience. Even a reporter in the back scribbled the moment down. It was the kind of comment that signaled not just surprise, but respect. Musk stayed composed. "Well, I've had about a $44 billion reason to understand the law as deeply as I can." Barrett cracked a small, fleeting smile. The tension that had colored the beginning of the hearing had subtly transformed into something else, a serious dialogue between intellectual equals. "I reviewed your filing on Youngstown and Bantam Books," Barrett continued. "Your argument that informal government pressure, especially when disguised as regulatory procedure, can constitute a First Amendment violation. It's persuasive, disturbingly so." Now even the Solicitor General looked unsettled. Barrett wasn't done. "What troubles me most," she said, "is not your defiance of the FCC's directives, but the documents suggesting that the agency knowingly sought to circumvent this court's prior decisions." She turned her attention back to the Solicitor General. Why were these communications not included in the original brief? Why was the court expected to rule without access to this context? He stammered something about procedural timing and ongoing FOIA litigation, but the momentum had already shifted. Justice Barrett returned her gaze to Musk. "Mr. Musk, I opened this hearing with concerns that your conduct represented a threat to regulatory order, but having reviewed your evidence, I'm now more concerned about the regulatory order itself." And just like that, the tone of the hearing changed forever. What began as an attempt to discipline a disruptive billionaire had become a reckoning for the very institutions that tried to rein him in. And Barrett, the sharp, by-the-book jurist, had just acknowledged it out loud for the record. No one had expected her to blink. But this wasn't blinking. This was Barrett realizing she might have been aiming at the wrong target all along. It didn't take long for the shockwaves from Musk's courtroom performance to ripple outward. Within 48 hours of the hearing, Silicon Valley wasn't just paying attention. It was in a quiet state of panic. Not because Elon Musk had embarrassed the FCC, but because he had revealed something the other tech giants feared more than fines: a paper trail. Inside Google's sprawling Mountain View campus, a closed-door emergency meeting convened on the 12th floor of the legal division. A senior counsel, still clutching a copy of Musk's exhibit packet, muttered, "If even half of this is real, we've been sleeping through a constitutional train wreck." Someone else in the room added, "And we've been funding it with compliance teams." That same day, Meta's legal team filed an urgent motion with the D.C. Circuit requesting clarification on the scope and legality of the FCC's recent moderation guidelines. The document didn't mention Musk by name, but it didn't have to. The phrase "prior restraints disguised as technical protocols" was a direct nod to the argument he had made before the court. Amazon soon followed suit, issuing an internal memo instructing its Alexa division to temporarily suspend implementation of certain data retention rules that had been pushed by the FCC under similar directives. The memo's subject line was blunt: FCC guidance, now a legal risk? Even Twitter, still X under Musk's leadership, posted a subtle but clear message through its official compliance channel. We welcome regulatory clarity grounded in constitutional principles. But it wasn't just the tech giants raising eyebrows. Legal blogs, constitutional think tanks, and law school faculty lounges lit up with conversation. The Musk Doctrine, they called it, half-jokingly, referring to the now viral quote. This wasn't non-compliance. This was constitutional resistance. At Harvard Law, a last-minute roundtable discussion attracted over 300 students and faculty. The topic? When regulation becomes censorship, the FCC after Musk. In Washington, D.C., things were less academic and far more political. Two FCC commissioners, both appointees under prior administrations, issued a joint statement cautiously welcoming a robust debate on constitutional limits and regulatory authority, a phrase so carefully worded it practically wore a seatbelt. But the most unexpected shift came from inside Apple. While famously secretive, a leaked email from their compliance division surfaced on a tech whistleblower blog. It read, "Begin review of all existing content moderation coordination with federal agencies. Prioritize communications from 2022 forward." That one sentence said it all. They were scared. Because what Elon Musk had done wasn't just clever legal maneuvering. He'd put the FCC, and by extension, every agency engaging in backdoor content pressure, on notice. And suddenly, no one wanted to be caught in the same trap. From boardrooms to break rooms, the question was no longer, did Elon win? It was, what else are they hiding? What Elon Musk exposed wasn't just a flaw in the FCC's oversight. It was a glimpse into a much bigger, more dangerous pattern, a system where power had slowly slipped away from the public and consolidated into unelected agencies and rubber-stamped regulations. And perhaps most concerning of all, very few had the means or the nerve to fight back. While big tech scrambled behind closed doors and the media tried to keep up with the fallout, Musk seemed to be the only one willing to say the quiet part out loud. This isn't just about X. It's about what happens when unelected bureaucrats think they're the final word, and no one has the guts to say no. And that's when everyday Americans started to pay attention. Talk radio shows lit up with callers, not just the usual crowd. Small business owners, veteran software engineers, even retired school teachers, all echoing a version of the same question. If Elon Musk can be targeted for speaking out, what chance do the rest of us have? At a diner in Des Moines, a 68-year-old Vietnam vet leaned over his coffee and said to no one in particular, "I didn't vote for the FCC. I didn't elect those folks, but they sure know how to make rules I have to live by." The waitress nodded, half listening, but fully agreeing. The imbalance was becoming hard to ignore. Agencies with sweeping enforcement power, writing rules faster than Congress could blink, all while shielding themselves with technical jargon and buried clauses. And unless you had a few $billion and a legal team fluent in constitutional law, your options were slim to none. This was the deeper issue Musk had quietly tapped into. Not just free speech or content moderation, but accountability. Who watches the watchers when the watchers answer to no one? One quote from his court exchange went viral for this very reason. The government didn't change the law. It outsourced the pressure. That's not regulation. That's coercion with plausible deniability. It resonated because it felt familiar, not just in tech, but across industries, healthcare, energy, education. Federal bodies issuing rules that affected millions without ever facing a vote, a debate, or a camera. And while the average citizen might not sit across from the Supreme Court justices with a red folder of receipts, Musk had, in a way, become their surrogate, a flawed, controversial, but undeniably effective one. Because what he exposed wasn't a partisan issue, it was an American one. And suddenly people weren't just talking about social media anymore. They were asking the bigger question: when did we stop being the ones in charge? And more importantly, what do we do now? By the time the dust settled, it was clear this wasn't just about Elon Musk anymore. What had started as a high-stakes courtroom drama featuring the world's richest man and one of America's most powerful justices had morphed into something far bigger, far messier, and far more personal for millions of Americans. Cable news had tried to frame it as a Musk versus the system story, but the people watching from their living rooms, their break rooms, and their smartphones saw it differently. They didn't see a billionaire playing hero. They saw someone finally pulling the curtain back on a machine they'd long suspected was broken. Musk hadn't just defended his company. He had, unintentionally or not, opened the floodgates for a national conversation that had been bottled up for years, about regulation without representation, about bureaucrats writing rules no one voted on, about a tech-literate population tired of being treated like they couldn't understand the very platforms they built their lives on. In barbershops in Detroit, diners in Oklahoma, and living rooms in South Carolina, the question kept coming up. If this can happen to him, what else is happening to us? Even skeptics began to reconsider. A 55-year-old teacher in Florida summed it up on a local radio call-in. "I'm no fan of Musk. I think he's arrogant. But what he said about unelected power hit me like a brick. My property taxes go up, my insurance premiums skyrocket, and I can't trace a single vote to any of it. Maybe we've all been asleep at the wheel." Even members of Congress, especially those who had stayed conveniently silent, now had to reckon with the fact that a public showdown had ignited something they could no longer ignore. A bipartisan group started pushing for a full congressional review of regulatory practices across federal agencies. For the first time in decades, there was talk of reining in the alphabet soup of bureaucracies with real enforceable limits. And amid all the chaos, one truth stood taller than the rest. Musk hadn't won in the traditional sense. There was no trophy, no final gavel slam that made everything perfect. But he had done something most people in power fear more than losing. He had shifted the narrative. Because this wasn't about content moderation. It wasn't about whether X should or shouldn't censor posts. It was about the structure behind it all, the invisible scaffolding of American power. And once the public saw it, really saw it, they couldn't unsee it. That's why this case would be studied for years. Not because of who Elon Musk is, but because of what his fight revealed. It was never just his battle, it was ours.